Hello everyone. Thank you for joining. It's a legal dictation of 500 words at 100 words per minute. Drop your suggestions in the comment box. Ready? 10 seconds. 5 seconds. The said land, as owner thereof, it was held that unless the LNDO pursuant to the said re-entry repossesses the property, the lessee of the land is fully entitled to deal with the tenants inducted in the property constructed over the said land as owner, landlord, and the tenants of the lessee cannot challenge the title of their landlord. Upon the senior counsel for the appellant being confronted with the said judgment, he had no reply thereto now. Therefore, it has to go by the earlier decision of the court, which has decided that matter justifiably as such. He contends that the Supreme Court in the said case, in a case of re-entry by the LNDO, had directed that possession of the premises to be delivered by the tenant to the LNDO and not to its landlord. We have on demo asked the senior counsel for the appellant whether the appellant is willing to hand over possession to the LNDO if not to the respondent bank. The answer is in negative. The said conduct of the appellant demonstrates the malefides of the appellant in seeking to retain possession of a valuable property in the prime central business district of the capital city of Delhi on some pretext or the other. The judgment in Bharat Sales Limited Supra turns on its own facts. That was a case under Section 14 of the Delhi Rent Control Act 1958, and in which proceedings the LNDO also a party. Such is not the case here. On the contrary, the plea of the LNDO has already been negatived while confirming the sale in favor of the respondent bank. The LNDO, having not taken any steps till now for repossessing the property, the appellant cannot wriggle out of eviction order if otherwise found to be validly passed by setting up a title in the LNDO. Moreover, the respondent is a nationalized bank and the LNDO has a policy of revoking the re-entry upon the reasons on account whereof re-entry was effected being remedied and the charges therefore being paid. There is nothing to suggest that the said charges cannot be recovered from the respondent bank. We therefore do not find any merit in the said ground of challenge. As far as the second ground aforesaid of challenge is concerned, the finding of the premises being required by the respondent bank is a finding of fact not interferable in writ jurisdiction, much less in an appeal arising therefrom. The appellant admittedly is an old tenant in the premises at a meager rent. This court in Iyer and Sons Private Limited versus LIC of India, affirmed recently in Life Insurance Corporation of India versus Damayanti Verma, has held a public sector bank as the respondent to be fully justified in endeavoring to earn maximum out of its properties. No case thus for interference with the findings of the estate officer affirmed by the district judge of the requirement of the premises by the respondent bank for its own use is made out and entitled to retain possession thereof. I hope you must have liked the dictation. Please like, share and subscribe for more dictations. Thank you.